we didn't get, a good bargain?
First and foremost, let me say that Wright has had quite a significant advantage sitting at home and has set out his case. For we lawyers, it's as if he's filed pleadings and we don't have pleadings and we have to speak to him. Because he sat back at home and set out a huge table, put his case together, and we have to respond. But we'll respond to his case. First and foremost, it's important to understand that we operate within a system of law. That's the most important thing. We don't operate within a system of self-serving, homemade arguments, which is thrown at the other side. That's not the system we operate on. Secondly, under Section 37 of our Evidence Act, documents emanating from official sources in terms of a report have that presumption of legitimacy. We have a situation where the Attorney General of the Republic of Ghana and officials or agencies appointed by the Republic have carried out an official duty. That official duty has a presumption of regularity. Mr. Simon's work does not have that presumption of regularity. So raised against that which is a presumption of regularity, that which has a presumption of regularity should supersede. Because if we are to follow his example, everybody will sit at home and draw his own flow chart. I appreciate the fact that we can have intellectual divergences, but those intellectual divergences should be fixed on the record and should not be self-serving and done just for your benefit. It has to speak to the record.
He's not cooking up the figures.
I'm not saying he's cooking up anything. We are in the Republic. He has put together figures. He says he's not cooked it up. It doesn't matter. The point is that documents emanating from official sources will take precedence over his work. And that's what I'm dealing with. And that's what we are obliged by law to deal with, and not by virtue of what is put together documents that he's speaking from home. That's not how it's done. We have to speak to documents from official source. That out of the way. For me as a lawyer and for other people, because he spoke of the adversarial system, the most important thing in this dispute or this discussion is what has been the effect of the law with respect to the figures. And I go back to the first issue. It's very important to understand that when the official administrator was appointed to administer the bank, it was for a period of 6 months. It was at this stage that the figure of 5.7 billion was thrown about. That figure, irrespective of the diminution or the attempt to demystify the caveats in the report, has now been shown to be inaccurate, which puts Mr. Simmons and the receiver on a collision course. Because while the receiver said 5.7 billion then and has revised his position, Mr. Simon has escalated it. Which one are we to take? I prefer the receiver's one because he's coming from an official source. Now, when you appointed a receiver of a bank, you have 6 months under the law to do your work. If the Bank of Ghana thinks that that 6-month period should be terminated earlier, under Section 122, there are 4 circumstances by which it should be done. The bank takes the position that the bank cannot be rehabilitated, the bank has to be liquidated, or there are other reasons. In this present situation, it was never done. It was never done. Therefore, the basis of the revocation of the license in itself was fraught with illegitimacy. And that's the thing that, as a society concerned with law and the adversarial process, we have to be concerned about.
We are talking about the same kind of sin that the Attorney General then flagged.
Well, perhaps we're on the same page.
Okay.
That kind of thinking is not one that I heard Mr. Simmons speak about. He never addressed it. He never spoke to it. He jumped it. But those are obstacles in our path, and that must be addressed. The question which arises for consideration is whether or not the revocation of the license was done properly. 6 months or 6 months period was given for the official receiver. It was not adhered to. Section 122 was completely forgotten. And then they moved on and then they pulled the bank's license. There is no evidence. For example, the receiver, upon giving the official administrator, upon giving the authority to administer the bank, set out a report. That report is not the kind of report that the Bank of Ghana could have revoked the license on, because the bank did not revoke the license under Section 16 of the Bank of Ghana, the Specialized Deposit Taking Act. Even under Section 16, the Bank of Ghana was required to give a month's notice to UniBank for them to make representations as to how the bank will have been rehabilitated. This was not done. The question then which comes back to the fore is that in the absence of these conditions precedents, are we not entitled to step back and ask ourselves, How do we move on from here?
So whether or not they gave them the opportunity to proffer an alternative as to how the bank could have been rescued, they still went ahead to do so.
They still went ahead
they
to do so.
They have suggested that they were going to inject 2 billion and subsequently 2 billion, and all of that was rejected.
That is correct. Now, this letter of, if I pull it back here, is a letter of 5th June 2018 in which this offer was made to the receiver. Unfortunately, this was not given serious consideration, and we've come back to square one. Mr. Bright Simmons talks about the fact that the shareholders of the bank had admitted to making recompense of 4.9 billion CDs or much more than that. If you read the letter, they speak of a ballpark estimate. A ballpark estimate. There is nothing indicating a full and complete admission that these were the figures. Remember, the receiver himself was in doubt about the figures. And it is for such reason that subsequently in court, the receiver comes down from 5.7 billion and finally ends at 2.8 billion, pays amended rate of summons and statement of claim. Then the receiver drops down to 2 billion. This 2 billion is made up of 800 in assets, and then you have 1.2 billion owed by third parties, as in creditors, debtors of the bank. The bank is in the business of lending money. So this is where we are when we talk of the bank's liabilities and what is to be recovered. And that's what Attorney General has done in Lolly Prosecution. When Mr. Bright Simmons condemns that process, he condemns that process without regard to the official record. And he cannot impugn an official record merely because it sits on the sidelines and chooses to disagree. He says that the Bank of Ghana did not agree because they thought that this will not do. Now, the question which arises here is this. At the time this letter was written, this was before the bank's license was revoked. I do not know where Mr. Simmons get his information that the Bank of Ghana thought that this will not work, because finally we've come back to full circle. In fact, if this had been taken into consideration then, perhaps we wouldn't be here. He says that 2 billion CDs in 2018 was not exactly what it is today. But then he does not say.
He's benchmarking with the dollar.
It's a good argument.
Using the value of the dollar.
It's a respectable argument. I would have been happy if he had carried that argument to also debts owed to the bank by the government of Ghana. Are we going to benchmark that to the dollar too? He's silent on that. And I don't think it's a fair argument to make. He has to look at the argument in a holistic manner, especially from where he's sitting. So Mr. Simmons' position on the exchange rate should be something that should be applicable to everybody. There's a whole lot of talk about shareholders having stolen money. Such miserable arguments being made but propagated in broad circles. Have shareholders stolen money? Because of these plans, equipment, and property issues and the ratio, the bank had taken the position, which had been brought up at board meetings and approved, the minutes are there, that some of these assets should be held in special purpose vehicles. When the receiver, the official administrator, came upon the bank, these things were disclosed to the administrator at that stage. They were not hidden. And that's why in the letter of 5th June 2018, you see in the third paragraph, they talk of immediately assign holders' interest in the assets sitting in the books of the bank. Part of other assets of about 3.7 billion, which were purchased by the bank, but registered in the name of holder to improve the solvency of the bank. This will be done together with the repayment plan for the direct loans to shareholders. So clearly, this idea of fictitious entries, yesterday I read a beautiful note by my learned friend on the other side, in which he spoke of fictitious loans, and it is for him that I make this point. These things were not hidden. They were put on the books to enable capital exposure limits, special limits, and had been put there for that purpose. They were never hidden. They were made clear from the beginning of day that these matters should be put into the system to enable the bank get back on its feet. No tangible reason has been given as to why this was not taken into consideration. He spoke of the liabilities of the assets of the bank having been transferred to CBG. The question is, under Section 1232 of the Bank of Ghana Act, the Bank of Ghana had no authority to split the good assets and the liabilities for the receiver and for the taking over bank. All the assets and liabilities under the law are contemplated to be within the bosom of the receiver. That is the law. The law does not say, even though I know this mechanism of structuring where you can move assets, good assets and bad liabilities to other places, the law says the assets and liabilities will be taken over by the receiver. In 2018, that was not done. The exchange rate has changed, and today we are being told by Mr. Simmons from a 31st March or 30th March documentation that the assets, the good assets, you should move those to 711 million. What was the value of the good assets in 2018? In 2018, when the issue occurred? These are very important questions that we have to look at.
You had mentioned that
yes,
it was bizarre to hear suggestions that some people had stolen any money, right?
Did I use the word bizarre?
Okay, that's my word.
Okay.
And that there was nothing like, theft.
Yes.
The charges, criminal charges, included dishonestly appropriating, or isn't it?
That is correct.
What is that?
How
is that different from stealing?
It is a semblance of. Prosecutors lay out their theory. The Attorney General himself, clearly in the face of the fact that these monies which go into shareholders for the purchase of the properties or for holder to hold the properties, clearly can now sees that because the properties were held in trust for the bank, there can be no stealing here. These properties at the end of the day were held for the bank. So that for people to make this argument is based on emotional drawbacks. The properties were held in trust for the bank. And they are on the books. It had been discussed at the board level and it had approved. And when the official administrator turned up, these matters were disclosed. They were never hidden. At best, they can be called misstatements. And if you go to the company, the Bank of Ghana, the law, Act 930, if you look at Section 94, I'm talking off the top of my head, the governor, the Bank of Ghana, can examine the books of a bank. And when they examine it and there are misstatements or misapplications, what they will do is that there's an administrative sanction, I believe under 98 to 100, between 98 to 100, where they can punish you by way of administrative sanctions or penalties. Thank you. But it has never been the case that this misclassifications becomes the basis for the revocation of a license. And that's why the law is important. If you put mad things in SPVs, does it then become a basis for revocation of a license? No. It does not become, because the primary remedy under the primary punishment under the law is that when that happens, the person suffers administrative sanctions, especially when the assets have not been looted away but are being held in trust for the bank.
Bottom line,
yes,
the state has a good deal in this approach to terminating the case.
I believe so. An Attorney General's duty is not necessarily to obtain a conviction, especially when the dispute centers on commercial malfeasance, because sometimes it's extremely difficult to prove. Mr. Bright Simmons was candid enough to say that the Attorney General has gone to court and thinks that within the adversarial system that we operate, this is what he can achieve. That concession that he makes should stop him from making further statements that we have not had a fair deal. Because when we go to court, we operate within an adversarial system. And that adversarial system requires us to operate by the rules. The rules and the facts now clearly show that these are the matters at hand. Their cooperation of the shareholders or the former directors to give to the government of Ghana to recover the 1.2 billion does not make the 1.2 billion a liability of theirs. So we have to get it very clearly. Unless Mr. Simmons can say somebody is stealing money. But there's no such evidence.
The minority has raised some questions.
Very well.
And the public is concerned.
Yes.
That this is an Attorney General who was lawyer for this same party.
True.
So smacks of conflict of interest, smacks of collusion to get his client off at the expense of the state.
I recall that in constitutional law class we were taught about the doctrine of necessity. If I became a Supreme Court judge tomorrow, is it the case that if something was concerning Kwame Akuffo, I could not sit upon it? If, for example, I was Chief Justice, tomorrow I couldn't hear the case? The Attorney General has found himself in an office where he has to deal with people that he acted for in the past. By virtue of the doctrine of necessity, he has to take a decision. I always say that when a person exercises a discretion, the mere fact that you have a disagreement with the person over the discretionary use of that power does not necessarily mean that the person is wrong. The question at stake is on the facts available. And on the basis of the reconciliation of 2 billion cedis, has the Attorney General taken a decision which is pragmatic, fair, reasonable, and considerate within the circumstances? Or should we continue litigating? You have to look at the cross-examination, for example, of some of the bank's witnesses, where, for example, in terms of the capital adequacy ratio, the method which had been used to calculate it, witnesses were pulling back, claiming they didn't even know who had done it. When the 5.7 billion cedis was put to witnesses, witnesses were stepping back as to how that figure had been arrived. An Attorney General is entitled to take a fair position before you lose the case, because you see, in a criminal prosecution, it's proof beyond reasonable doubt. So at the end of the day, taking into consideration the fact that the revocation of the license was not done properly, and that's a matter that Mr. Simmons, for all his scholarship, does not speak about. Perhaps you do a counterclaim when we are finished speaking, but he doesn't speak about that. And we, for us as lawyers, always say that you can't put something on nothing and expect it to stand. So we have a situation where the revocation itself was improper. We have a situation where the audit figures have kept changing. Nobody can make the reasonable argument, can make the stand-up argument that the receiver is now in collusion with the debtors. It will be untidy to say so. So if the receiver today says in court, by way of his amended writ of summons, as had, just give me a minute, let me just check.
Sometime in 2024.
20th of March 2024, says that the debt then was 2.8 billion. And remember, at the time that he cascaded down from 5.7 to 2.8, it was not a settlement issue. It was not a settlement issue because they were now getting to grips with the full picture of the situation. That reduction was significant. But then again, the bank had lost its license on the basis of a figure that has now changed. Who is asking that question? Mr. Simmons doesn't speak to it.
From where you say that is an unfair treatment,
I don't like
by the state against the bank.
I don't like to put this emotional tax on issues. I just like to put the facts forward. I like to say clearly, or I like to submit clearly, that the figure upon which the bank lost its license has now changed, and it changed in court.
So if they are very, strong about that point, they shouldn't be interested in settling. They should rather be interested in pushing this against the government and seeking that in the end, their license is restored and the government pays for the wrong they committed against them.
The point at stake is that people do not, nobody has the eye of the evil prophet to see tomorrow. Sometimes you may think you have a very good case in court, but the judge may see differently. And therefore, sometimes when, as they say, what's this thing saying in Julius Caesar, there's a tide in the face of men, which when taken at the flood leads unto fortune. Omitted all the voyage of life is bound in shallows and miseries. On such a full sea are we now afloat, and we must take the current as it serves or lose our ventures. Perhaps that's how they see it. I cannot get into their minds. But sometimes it's important to take what you have rather than to wait for the end. The question is, or the fundamental point that we can never run away from, is that the license was revoked on a figure which has now changed.
That's the point you have made a number of times now.
Yes, I was emphasizing this, so I come down to it. So now that we've come down to 2 billion cedis, and the apportionment and the components have been made very clear, and Attorney General is settling on it, people have said, for example, why is he entering a nolle prosequi? Why is he not going under Section 35? Why is he not going under the Plea Bargaining Act? Our law makes provision for these things when people are pleading guilty. Nobody has ever explored the thinking that when there's a criminal case running and a civil case running, and the government sees that it cannot win, it cannot force somebody into a plea bargain position, and therefore can enter into a consensual settlement. So I like to say to those who make that argument that clearly Section 35 and 70 of the Plea Bargaining Act are not applicable to the facts of this case.
Because you must plead guilty first.
Yes.
Before there will be a plea bargain agreement.
Absolutely.
Okay.
In this case where it's a 50-50 take, and there's an absence of guilt or admitted guilt on the part of the shareholders, there can be no reference to these particular sections that people are propagating.
Okay.
I'll yield back for now.
It's I'm beginning to appreciate it from this point that it's as if, these individuals are saying, you members of the public suggesting as though we were down, guilty, down, and some favor is being done us. Sorry, no favor is being done us. We don't believe that we would have lost this matter. But Oliver, did you also speak too early when you